We are joined today by Stuart M. Nachbar, and by the way, the M stands for My Kid Needs Your Help. Is that true?
No, it's not true, but thank you for the compliment.
Well, you would admit that you are an attorney at law of the state of New Jersey, correct?
Yes, I am.
All right. I want to talk to you about something. Would you say that your relationship with your adversaries from the school boards is collaborative, or is it truly adversarial, where you're fighting over every penny?
Oh, no, absolutely, it's collaborative.
Okay, and what do you attribute that? Just the level of professionalism? In other words, everybody knows the law, everybody knows the needs of the child, everybody knows if the case were to be tried, what the outcome would be, so you really just try to get to the end quickly?
Well, it's partially that. It's a lot of the professionalism within the special needs community.
Right.
It's also the fact that the framework for a hearing before an ALJ is much more informal than it is in the state courts. For example, in state courts you use depositions, use interrogatories, notice to produce, very formalized discovery methods.
Right. And administrative law, what do you do there?
Administrative law, it actually says it's not a formal discovery. You should freely exchange the information.
The school doesn't think that a CST is necessary for the child, and you do.
Well, they have 10 days to respond.
Okay.
And if they don't respond, then you can demand it. If they, again, ignore your demand, then you can have the child evaluated on your own. And if need be, you can file for a due process hearing to have the child evaluated.
Well, what is a due process hearing?
Really just a hearing before the ALJ that says why we believe that this child should be evaluated. Here's our evidence. The school is saying no, and they have no reason for it.
Why would the school say no, though? Is it a money issue normally?
Could be a money issue, could be a timing issue. It could be something as simple as we don't have the resource for it.
Mm-hmm. Where do you get into the point where you're actually going to have to, get into some serious fighting with the school board or with the attorney for the Board of Education? In other words, where does the resistance get to the point where you've got to really start filing, lawsuits and getting in before the Office of Administrative Law?
If the parents and the school district can't agree and can't come to a resolution to benefit the child, mm-hmm. then unfortunately, after mediation, it has to go before the ALJ.
Can you give a couple of examples from your own experience about where it's been necessary to go to the ALJ because you just couldn't work it out informally?
I've had parents who demand that the child is taken out of the school district and put into a private school mm-hmm. because they don't feel that the education is beneficial, because the school district may not be living up to its end of the IEP, the Individualized Education Plan. You could have a situation where the school district has breached the IEP, because remember, the IEP is a contract between the school district, the school board, and the family.
Can we talk a little bit about how you get to the point where there actually is a formalized IEP? How do we get to that point?
A formalized IEP is done by the CST. The Child Study Team develops the Individualized Education Plan. But what you have to remember is that the CST, the Child Study Team, also encompasses the parent. The parent has an absolute right to be part of the Child Study Team.